Mr. Warwick.
My lords and my lady, it might help if I just give you a little ground plan of where I'm going. I'm going to deal with grounds 1 and 2 first, which are the timing points and essentially where I'm defending Judge Cook's position. Then I'm going to move on to grounds 3 and 4. I plan to deal with it in the following way. I'm going to make some general remarks about the importance of the appeal, one of 2 of which are redundant comments that have been made from the bench this morning. Then I'm going to deal with the legal submissions on both grounds. That not only means responding to some of the points Maloney Friend has made, but there's some additional points which you may have guessed coming from my skeleton which haven't been addressed at all by Maloney Friend for obvious reasons. And then after I've dealt with all those general points, I'm then going to turn to the 2 specific grounds which deal with specific provisions in the lease. So starting at the beginning with grounds 1 and 2, the first question, ground 1, is the question that was framed by Judge Cook, really forensically, at paragraph 24 of her judgment on page 100 of the core bundle, where she simply asked, why should it be the case that if notice of the revised amount of the interim service charge was not given, no less than a month before the commencement of the financial year, it could not be given at all? And another way of putting it is to say, what if that notice was given but was a day late or 2 days late? And the reason I'm obviously moving away slightly from the facts of this case is obviously this appeal has been brought on by Lord Justice Arnold's grant of permission because it's perceived that it will have considerable effect on many other cases, and service charges are much litigated up and down the land. What is the position about time limits for final service charges? We know in relation to this particular lease that it's not suggested that the provisions for what I call final service charge or the actual annual certificate that comes are not of the essence. I would submit, do submit, that generally speaking, provisions as to what I call those final service charges, normally year by year, those provisions are not of the essence. I've mentioned in my skeleton a case called Borovic, which is tab 6, the bundle. It's a decision at first instance, but essentially the sentiment therein has been followed ever since. And I don't, since the point doesn't seem to be challenged, I'm not going to go through Borovic. It's interesting in that despite the tenant who was arguing that times were of the essence of the procedure in that case, at that stage, the United Scientific case had only got as far as the Court of Appeal and hadn't reached the House of Lords. But despite that, the decision was made that the time limits weren't of the essence, and so obviously the position's all the more a fortiori. Now, the linchpin of Judge Cook's decision in this case was the UCH case, as I call it, United Scientific. You've been taken to some parts of that in Maloney Friend's address to you. I wonder if I can go back to that. It's tab 7 in the bundle of authorities. The principles are flagged there. I just wanted to take you to 2 passages. Firstly, page 930. And there's a passage, in fact the whole passage is flagged, but particularly if one looks at beginning at B, there the Court of Appeal was focusing on it being a unilateral right, and it's explained there, and particularly between C and D. It's an event on the occurrence of which the tenant has in his existing contract already accepted an obligation to pay, so that comment and the comments running down, certainly to E, are very pertinent in this case. So there was a scheme as regards rent review which allowed or provided for the tenant to have to pay increased rent. That scheme was a pre-existing scheme, just as we have a pre-existing scheme in our lease, and Lord Diplock and his brethren were of the view that that general position meant that time was not of the essence. What I thought might be helpful, and this is going to be my other reference to the USH case, is to look at the 2 cases, or one of the 2 cases, that were actually taken on appeal. And it's the second case, because that underlines the fact that you can have all this machinery and yet it's decided time is not of the essence. So if it's the Cheapside case, it's over on page 932 at letter E. You had a lease for 21 years, and you had, for the second and third periods of 7 years, rents to be determined in accordance with the provisions of a second schedule. If you look at paragraph 3 at letter G on page 932, you'll see the market rent may be determined and notified to the lessees in the manner following. And then little a, the rent shall be specified by a notice in writing, the lessor's notice, served by the lessors or the surveyor not more than 12 months, nor less than 6 months prior to the review date. Careful. Then the lessees could respond, and then going on in the procedure, if there was a response, then just above B, there could be an application made of the lessors by the president for the time being at the institution, whose valuation would be made by an expert and not as an arbitrator. And so, just below the quotation from the provision in the lease, Lord Diplock says these provisions contain an elaborate timetable as to what to be done in various eventualities, not only by the landlord and tenant, but by other persons. And then he explains the procedure for determining the market rent has to be initiated by the landlord, by a lessor's notice. This must be served between 12 and 6 months before the review date, and constitutes an offer irrevocable for a month during which the tenant may accept the proposal or make a counter-offer. And then just dropping down a little bit, just below E, in two respects, under the terms of the review clause, the progress of the procedure for determining the new rent is or may become within the exclusive control of the landlord. He can initiate the procedure. He alone can apply to the president of the RICS if negotiations don't result in agreement. And so then you've got the tenant's position explained at F, and then just below, which it's obviously not C, it's G, if the tenant reckons the advantage of knowing before the review date exactly how much higher his new rent will be outweighs the economic benefit of having the use of the money representing the difference until the new rent has been determined, he has the remedy in his own hands, quite apart from the fact that he can get a pretty good idea of what the market rent is from his own surveyor, or can himself offer to enter into negotiations with the landlord before the stipulated time for serving a lessor's notice has expired. So as soon as that time has elapsed, he can give to the landlord notice, specifying a period in which he requires the landlord to serve the notice, and the like. And the Lord Diplock and the others in the House of Lords don't seem to have been concerned, or if they were concerned, they were able to allay their concerns by saying, well, the tenant, and of course you get commercial tenants, great and small, it could be a small little shop of less value than a valuable lease, so you can't make any assumptions in this day and age that leases aren't extremely valuable. That what's the comparison here between service charges and rent? Service charges are often expressed in leases as being recoverable as rent, although in this case that's not the situation. But there is a very close analogy between service charges, which after all are pure money, and the rent. And so we say that Judge Cook's intuitive decision, which in fact she made previously, as you've heard, that time was not of the essence, was the correct one. And I'm coming in a little while to what is effectively ground 2, but ground 1 is the time limit that's expressed in this lease set in stone? And we say...
I'm still waiting to find out the answer to why that is not the case on the language of this clause, because it's all very well to show us a case about rent review, and you've already pointed very fairly to the point of distinction between the two. In the second of the appeals in the United Scientific case, the tenant had a remedy, could accelerate the position by forcing the landlord to serve a notice. And there was a mechanism for doing that. So the tenant wasn't particularly disadvantaged by the landlord's failure to serve it. But here we've got a provision which says you must do it by no later than a certain date, which is intended to trigger an obligation on the tenant to pay on particular dates, April and October. And why shouldn't it mean what it says?
Well, my lady, if I break down the structure of our lease and contrast it with the position in the USH case, the particular case, there was a timing, an express time that had to be made, and if we say that it had to be no later effectively than 6 months before the relevant rent review period. So, and what the court in USH said is, well, the tenant can serve a notice. If time is not of the essence, the tenant can serve a notice making time of the essence. Why, I would suggest, forensically, cannot the same be done in a case like this?
Because there's no mechanism for the tenant to serve any notice.
Well, there isn't a mechanism. This is, as I understand it, under USH, this is just looking at the general law, whereby where time is not of the essence, then it's possible for time to be made of the essence by the other party serving a notice doing so.
On your interpretation, does that notice making time of the essence have to be served more than 1 month before the financial year?
No, my lord, on my analysis, the notice can be served by the tenant at any juncture. The tenant might choose to wait to see what happens, or it's in the tenants. The tenants are not the novices that I think my learned friend would wish to portray them. Like landlords, lessees range across a vast array. There are those who may be not so well informed, and there may be those who are very well informed, and they decide they know exactly what's going on in the building, because normally there are circulars and the things going around, so they know what money has been spent, or approximately what money has been spent. There are managing agents. They can ask the managing agents what money is being spent. So there is...
That's just not realistic. In the real world, you don't spend your life asking the managing agents how much money they've spent on the upkeep of the building until they provide you with their service charge estimates. It might be in a commercial context, but in the normal context where you're renting a property, it seems to me that the suggestion that a tenant would know that you could serve a notice making time of the essence detracts from the basic proposition that a lease is supposed to tell both the landlord and the tenant where they stand without having to go to a lawyer.
Well, my lady, I fully understand the sentiment behind that comment. The difficulty is, if we scroll back time to when I was appearing in the House of Lords in USH, and I'm afraid I wasn't, actually I think I was in practice then, but if I'd been doing that, you could have been one of the lordships, or a ladyship, putting that question to me and saying exactly the same thing. But as it happens, the House of Lords were persuaded to depart from the Court of Appeal decision and decide that although there was fixed time limits, as you've seen, nonetheless they could forget about the fixed time limits, or at least they were not of the essence. And then if they were not of the essence, they've said notice can be served. Now, your position might be, oh well, with a residential lease, where there are service charges, in some way the background is different to a commercial lease. But as I've indicated, you can have, I do cases involving flats that are worth £50 million in comparison to a little tobacconist shop. So the analogy between residential and commercial is not a very solid one upon which to base the distinction between the commercial approach for rent review and a mechanism for charging more service charges, as we've got under our residential lease.
How can an asserted existence of a general right to serve a notice making time of the essence be an aid to construction of the underlying clause?
But Lord, I'm not suggesting it can.
Okay.
What I'm suggesting is that one of the arguments that's put up against me, in fact, I've been addressing a couple of the arguments that were put up against me as to what the underlying policy is behind this, and the importance of the tenant knowing exactly where the tenant stands. Those are overstated, and I agree with you. Your approach here in this case, which frankly I think would have to be the same approach whether it was commercial or residential, because you have many cases. The only difference, and it's a very important difference to which I'll turn, between residential service charges and commercial, is residential have got this increasingly complex code of statutory interventions, whereas commercial have not. But and I'm going to be turning to some of the vexed questions that arise as to where you use the existence of a statutory code to guide you in your construction. The learned friend has got certain suggestions with which I'm afraid I disagree. But the basic point, I agree with you, is what do those words mean? And that approach is surely the same, whatever the nature of the underlying premises that are the subject matter of the lease.
Just help me. When Lord Diplock refers to service of a lessor's notice to the tenant seeking to deal with the position,
He's quoting from page 932, letter G, just 3 lines down in the middle of paragraph 3, where there's a definition of lessor's notice.
Yes, I see. And you say he's then referring to the lessee seeking to make time of the essence.
Yes. That's one of the. That's one of the. It was obviously put, just as my lady has put to me. Well,
Yes.
golly, there's a time limit. Any tenant can read this. Surely it is what it is. And here we have a universal House of Lords decision saying no, black doesn't mean black.
In the context of rent review, where the consequences would be for the landlord that he loses his opportunity if the alternative construction were adopted, that if he's 1 day late, he loses his opportunity for years potentially to
Yes.
up the rent. And you can see that commercially why it might be said that that wasn't the intended consequence if he was a day late, but that's miles away from this situation, isn't it?
Well, rightly, the appellants in this case have two separate grounds. Ground one is seeking to persuade you that time is of the essence. Ground two is, if time is not of the essence, then where do we go from here? Now, I do recognise that I get into increasingly tricky territory as we progress through the grounds of ground two. But ground one, I would respectfully suggest I have no difficulty submitting, but can it really be thought to be wrong that the landlord somehow, it's all ready to be sent out, this notice, increasing, because the figures were, there was a historical figure in, and you often get this in these older leases, there is a historical figure for the rent, for the service charge, which then can be increased, as my Lord said, by some kind of trigger notice. Now, is it to be the case that because the landlord or the landlord's managing agents are a little slow off the mark and they miss the notice by a day or two, that means that they've lost the chance for that whole year to get in the interim amounts? And
Would it be the whole year or half a year?
I think it, well, it has to be.
It's got to be no later than the a month before the year end, isn't that right?
Oh,
Previous year end.
It's let's just turn up the provision in the supplementary bundle. It's I think it's page 10.
Yeah.
And little x at the bottom of the page. Notice of the revision and adjustment to be served on the lessee not less than 1 month prior to the commencement of the financial year. Yeah. So they get, every year they get a one-off opportunity to serve the notice.
Yes.
And so I'm, for the purposes of ground one, I'm postulating a situation where there's some kind of mix-up, and so this notice that would have gone out has missed by a day or two. So they're still before the end of the financial year, but they've missed out. And you're being asked, as I understand it, to say, in principle, where you have a mechanism comparable to this, but missing, a miss is as good as a mile, is the colloquial expression. And we would respectfully submit that you shouldn't be persuaded to go down that road, or at least in, not in relation to this lease and not at all. If you feel that time of the essence might be the case with this lease, no doubt you would say so, and then you would explain why this case is to be drawn in contradiction or contrast to many other cases where there are interim provisions. Because the interim provisions vary enormously from lease to lease, but there normally is, except in the very old leases, where no one had even thought of inflation, 99 years ago, but in the more modern leases, people have got some kind of mechanism for money on account, and then they have what's called final. Yeah. And so that timing question will crop up in many different guises in the leases, and I would respectfully submit, and do submit, in line with ground one, time is not of the essence. And these things about you must feel sorry for the lessee, for the torrent, these are not the motive by which you should arrive at your decision. But I do agree, you arrive at your decision by construing the words used. But by construing the words used, however much you do it, isn't going to prevent you coming to a conclusion that a notice that arrives a couple of days late is a notice that is bad. We submit, no, it's not. And I'm not sure, really, that any amount of advocacy on my part is really going to improve the point. It's that intuitive point that Judge Cook took, and in line with her previous decision.
In other words, the contract doesn't actually mean what it says.
But the lady, I would be saying the same about UCH and...
Yeah,
and
I'm sure you would, but that's really what it boils down to. Yeah. The contract says you've got to do something by a certain time limit.
Yes.
Obviously, you're not in breach of contract. if you don't serve a notice by that time limit, because we're not dealing here with a breach situation. We're dealing with something that confers a benefit on the landlord in the form that he is. I don't know if you disagree with this, but the way that my lord put it, he's able to look forward to. He anticipates how much he's likely to have to expend on this property, and it gives him the advantage of recouping a certain proportion of that, so that he can do his cash flow over a period of time, and he gets more than what is stipulated in this lease as the sort of basic amount that you get every 6 months.
Yeah.
So in order to get that advantage, he serves his notice.
Yeah.
So the notice is a mechanism for conferring an advantage, a contractual advantage on the landlord that he would not otherwise have. But failure to serve the notice doesn't actually result in any consequences of payments of damages or anything of that kind. So it's not a breach of contract in which time being of the essence might actually have that sort of ramification.
But if I could tweak the facts of the USH case, or the one Cheapside case that's referred to here, they become closer to ours. You do get leases where you have rent reviews every year.
Yes.
So what if then, now applying USH, you miss your deadline, say it was exactly like otherwise, the covenant we got here, not less than a month prior to the commencement of the financial year. If it was the context of a rent review, you miss, but it doesn't matter. You are being invited to say, in the context of service charges, if you miss, it does matter, and it's fatal. And that means that it's all very well, it's important from cash flow, but that means the landlord has a tangible loss, because the landlord loses the opportunity, which increases over the years, between the rather small sum that was expressed when the lease was entered into and the increased amount that everyone would expect you would normally pay by means of cash flow and to help the landlord out. Because the money has to come from somewhere.
But there is a difference, isn't there? With the rent review, if you miss the deadline and time is of the essence, you can never increase the rent for the relevant period.
Yes.
Whereas with an interim service charge, you can still get the service charge eventually.
You can. I agree that there is a true analogy, but it's not a perfect analogy.
Yeah.
If the landlord can't recover the money on account, there's normally no mechanism for interest, because you only get, obviously, you can only serve your final demand when you finish your year and when you get your act together. And that isn't being rude about landlords. It often takes some time to get in all the relevant material. So there's quite a long time lag before you can get your increased amount. So there will be a loss, or not loss in this sense, there will be a deficiency between what the landlord has had to pay out over the year and what the landlord will recover on the final account, which of course is why you have interims. So there is some suffering if the landlord can't recover the interims. It's not losing it forever, because you can get it under the finals, but you are losing. And who's going to make up the difference? There isn't anyone to make up the difference, and so the value of the interest to the landlord becomes depreciated. And as I'll be saying in a different context in a little while, so many of these blocks now, for either property purchase reasons or because statute has given rights to lessees, more and more are they're owned by the lessees, lessee-owned blocks. And so maybe I don't make any progress, but there is a lot to be said for not treating landlords as all bad and all tenants as good. There are many people out there who are particularly lessee-owned blocks, that they have to get along on a bit of a shoestring, because they can't spend lots of money, because in the end they are paying for it through. I mean, of course, it would be wonderful if you could engage some top 10 firm of lawyers in the city to help you with this, but in practice nobody ever does that.
Well, if it's any consolation to you, Mr. Warwick, I live in one myself.
Yes, well, I'm not surprised to hear that, my lady, because so often when I address the bench, I find that some of the judges, many of the judges, I actually had the misfortune once to be told by the judge the very block was one where he had a flat. But, that's not so easy going.
Okay. Can I just check one very academic question?
Yeah.
So suppose you're right that time isn't of the essence.
Yeah.
And suppose the landlord then serves a notice late.
Yeah.
You say the notice can still have effect. Is the landlord in breach?
Well, it would depend.
For serving beyond the permitted time limit. I mean, in the average case, it would be a point with no practical importance, but theoretically, is the landlord in breach because he has served late?
There are indications in the authorities that the landlord would be in breach.
Yeah.
Can I ask you a variation on that question?
Yes.
What difference to the meaning of this clause would it make if instead of saying not less than 1 month, it had said not less than 1 week?
I think the principle we were debating would be the same. Because this will have a knock-on effect when we get to ground 2, but on ground 1, you could still be a day or 2 late. Mm-hmm. So what we're doing is we're teasing out the different procedures and testing whether there's a true analogy, whether Judge Cook
Well, logically, actually, if you're right, if you take out the words not less than 1 month and it said notice should be served on the lessee prior to the commencement of that financial year,
yes,
then if he serves it on the first day of the next financial year, he can still serve a valid notice.
yes.
Which rather begs the question, what on earth is the point in having the time limit at all?
Well, generally speaking, there are time limits both in terms of rent review and in relation to increasing service charges. I'm not sure we've got any cases which are like the example you pose.
No,
So,
but it's right, isn't it? As a matter of logic, it's got to be right.
Well, ground 2 might operate differently in that scenario.
Yes.
Yeah.
I've understood the facts correctly.
Yeah.
Once you're into the new financial year, if ground 2 were right, then potentially it's just too late.
Yes, yes. Well, and I've already indicated, without completely giving everything away, that moving on to ground 2, the territory becomes trickier as time goes by. You've got, on our clause, you've got a month. So you could get it in within the month, and otherwise it doesn't do damage, I would respectfully submit, to the structure. Once you've gone beyond that month, then it becomes, my submissions become more difficult.
Yes.
The principled approach, so I need to flag this up, again in deference to Judge Cook, is that the date from which the new rent is payable under the rent review is going back to the rent review date. So if you've still got USH open in front of you, tab 7, it's page 934, letter G. The landlord's sort of declaration, the market rent is determined by the valuer. If higher than £117,340 a year, would be recoverable with effect from April 8, 1975, i.e. retrospectively to the review date. And then there's a little discussion of the law, and the conclusion is, if you go over the page to E, I'm leaving out discussion of the medieval concept of distress and the like. My lords, until the rent review clause in the instant case, the market rent is determined in accordance with the provision is expressed to be payable in respect of the second period. That's the 7 years starting on the review date. Until the market rent's been ascertained, the landlords can only recover the old rent, which corresponds to the minimum in Walsh and Lonsdale. It's only when the market rent has been determined and turns out to be higher than 117,340, the landowner can recover on the rent day following such determination the balance he's been accruing since April 8, 1975. So, putting my submission at its highest, I would say that you can serve your notice, even if you've missed the month and the month has gone by, you're then into the new year, the new financial year. You can serve it at any time, and indeed you can go into the next financial and the next financial year. The tenant's remedy, if it sees all this going by, is to say, well, I don't want to find that my final service charges are going to be high. I'd rather pay by cash flow from time to time. So I'm postulating the hypothetical tenant who, after, say, a month has gone by, we're now into the financial year, consults the solicitor and says, what happens now? The solicitor says, well, you haven't had the increased demand yet, but look, you know that obviously service charges are running at a higher rate because you've only got to look at last year's full account or the year before's full account, and or you know works have been done. So you just write to the landlord saying, if you're intending to exercise your right under little x, then please tell us, and what is your figure? And if the landlord ignores it and does nothing, then you're home and dry, because you then don't have to worry about the interims being operated.
I just look at this clause from the point of view as a basic contract between A and B, and what you're postulating, putting its case at its highest, is that the words shall serve notice of such revision to be served not less than 1 month prior to the commencement of that financial year, is to be interpreted as meaning can be served at any time at the discretion of the landlord, even 3 years down the line. Now, speaking entirely for myself, I just can't see how any objective interpreter of that clause, reading it, would read it that way.
Well,
unless you're an extremely clever property lawyer.
well, happily I'm the role of the advocate. I'm not here to make the decision. But as I said, I'm putting the position at its highest,
yes,
because this is in a line with what Judge Cook was deciding, is presumably what she would say if she was standing here and she was having to justify her decision. Presumably this is what she would say.
Other than the fact that in a different case she decided precisely the opposite and did actually put a time limit on it.
Well, that's true. That might make her particularly uncomfortable as an advocate, but that is the position. It's not unknown for advocates to argue position A in one case and position B in another. So
she was at least very consistent in saying time wasn't of the essence.
Yes.
And some of what was being put to you in terms of forget about what the contract says would equally have applied in United Scientific Holdings.
Yes, yes. So
I must say that I can see more force in your point about not less than 1 month before the commencement of the financial year. You treat the financial year as the long stop.
Yes.
And that there might potentially be consequences, I suppose, about truncating the notice period, but doesn't necessarily mean that you stop the notice being valid.
Yes. Well, I looked up this case on the internet to see who the judges were going to be, but you hadn't been allocated at that stage. But there's a little summary, and I see that it's flagged up as being, interim rates and interim rents, and whether time of the interim service charges and where time is of the essence. So this is a case that, sorry, you've probably heard this all the time in appeals, but will have ramifications depending on the principle. You may decide that you can find it easier to decide on the language of this lease, but I will have to live with the results of this case, as will so many other property lawyers down the road. Anyway, that's, unless you want me to say more, that's what I was proposing to say about grounds 1 and 2. So I move on to grounds 3 and 4. I've got, I think, 3 general remarks about the importance of the appeal. Remark 1 I've really trailed already, because I was going to say that provisions enabling landlords to recover legal costs in the residential context are increasingly important, because more and more blocks of flats, or they don't have to be a block, they could be a divided up house, but whatever it is, more and more units that are divided into flats are owned by the tenants. They're either owned by the tenants because they were given to the tenants because it's a new build, and often it's part of the structure that when the property developer has got all this money and he's not interested in being a landlord after 99 years or 999 years, so it's often part of the structure that the lessees get to buy the freehold. Or they may subsequently, as happened in this case, buy the freehold, or they may, not acquiring the freehold, but they may acquire management rights. I've jotted in my notes here part 2 of the Commonhold and Leasehold Reform Act 2002, which gives you rights to apply to manage. If you don't feel that the landlord's managing agents are doing a good job, you can say you do. But of course, whatever you do, you are lumbered with the, sorry to use the colloquialism, but you are stuck with the existing structure of the lease. And this problem isn't, it's not an us and them problem, it's an us and us problem, where you've got lessees and lessee-owned blocks. The second general point is that Parliament has increasingly placed legal hurdles in the way of enforcing tenants' covenants, which therefore oblige the landlords to incur legal costs. You can see I've couched that from a landlord point of view, just as Maloney Friend was couching his submissions from a tenant point of view. But nonetheless, whether you call them legal hurdles or whether you call them legal protections, there are increasing numbers of bits of statute law giving rights to tenants. And all of you may have been featured in cases where you've come across some aspects of the vast array of protection that there is. Now, construing covenants regarding costs in a way that prevents the recovery of costs will inevitably create a shortfall. That's the point the Lord Justice Newey made shortly before the short break. And I've written down here, unless a pragmatic solution is found, and that of course depends on everyone cooperating, the landlord company will become insolvent. And that's not in the interests of either the landlord or the tenants. And there are, maybe I get all the bad cases, but I certainly get quite a lot of cases where something like this has happened. And my learned friend I jotted down some of the things he suggested you might do. Take advice, he said. Well, that's not going to be a solution to the lessees already there. It may be, if you take advice from very good lawyers before you buy a unit, they might spot, the language of the landlord recovery provisions, but the law's pretty complicated, and so quite what advice you would get from the ordinary conveyancer, I don't know. Then he said, well, we could apply for the appointment of a manager, and he mentioned Aldford House. A very poor example, I'm bound to say. Amongst property lawyers, Aldford House has been wonderful manna from heaven. I was featured in the litigation. I had a walk-on part a few years ago. I think if you took a straw poll of property lawyers, you'd find many of them have got involved in that. As my learned friend, as my lord said, the managership appointments can be very vexed. The last one I did was last November. It took a week in the FTT because the lessees were very wealthy and they chose to disagree. So, of course, if you have unanimity, then you might find that you've come up with some solution. But I regret to say that is not commonly the situation. So what's going to happen is, this isn't in terrorem, this is just realism. If you construe obligations in leases generally, we'll come to our obligations in a little while, if you construe them narrowly so that the landlord can't recover certain costs, one simply asks, where will those costs come from? Because there isn't a landlord on this hypothesis, in all these categories of case, that either the landlord is an independent body, and in which case it may not be keen to fund the legal costs itself anyway, and may then choose that as the trigger to get rid of the block. Because if the block is not making any money, you then offer it on the open market. Who will come along and buy this block, which has got, as it will then be perceived, following the judgments of this court, again, not in terrorem, but as blighted. This is a defect, this lease, because it has this form of wording. And so this actually is something that as property lawyers, if you're in the know, you do tend to look through the leases to see what it says about costs.
You say it's not in terrorem, but the way it's presented to us by the appellant is this is a lease which has been rendered defective by the changes that you've referred to, making enforcement of this and that, the other more difficult.
Yes.
And that if we look at it as we're encouraged to do at the time of the execution, this problem simply doesn't exist and therefore should not come into our thinking.
Well, I will be, one of my legal submissions is that you do not have regard to the state of the statute law at the time the lease was entered into. And I will be referring to Lewison, the book, and some authority which indicates that you don't do this. I have to say, in one of the earlier cases, and it's actually in the bundle of authorities, I flirted with the submission that you do have regard to the statutory code at the time, although my learned friend and I disagreed on exactly what the statutory code meant and that kind of thing. But I'm saying I'm resigning from that. The principled approach, and I will tell you shortly why, is that you don't have regard to the statutory code that was in existence at the time. You can tie yourself in knots, it creates anomalies, all kinds of things. So I although you're right to point that out to me, I'm going to address that full on. That's not something that should feature. I will be simply saying, you look at the language used, and then at the time when the issue arises, you ask, does the cost that we're talking about fall within those words?
But you also look at the factual matrix, because it's a contract.
You do. But here is the tricky thing. When you look at the factual matrix, is it stuck with the date of the lease, or do you construe what's happened in the meantime? Because, of course...
Well, it can't be the latter, because it's trite law that when you construe a contract, you look at the contract at the date when it's signed.
Well, what I'll do is I'll come to that point.
Should we have a go at you when you come to this?
Yes, sorry.
Yes, you can.
But your interorum point, which isn't an interorum point, but it's a point well made, that one has to look at the practical ramifications of adopting too narrow and non-pragmatic a construction because of what may happen in the future.
Yeah.
You have to set against that the fact that no doubt exactly the same thing could have been said to the courts which decided that clauses were too narrow to cover landlords' costs in other cases.
Yeah. Well, there have been quite a lot of cases at lower levels, and there have been one or two at this level which we will have to look at. But I'm not going to get sucked into all the cases at the lower level, because these partly because that is specifically one of my submissions, that you can't do that. You can't compare one case with wording X with another case with wording Y. It just doesn't work. Anyway, reverting to what was my second point, which is the statutory legal hurdles that are coming along, depending on the construction of the provisions relating to costs, this can create problems. Obviously, going forward, my learned friend said, nowadays, with the benefit of these ever-extending leases, people slot in these clauses. That's no consolation to probably the majority, probably substantial majority of people, because leases, as you will know, go back many years. The concept of there being flats, residential flats, goes back into the 19th century. So there can be many leases still existing which don't have anything like this kind of provision. And to say that therefore the lease will be sold is no solution, because if it goes bust, or the old landlord, the third-party landlord, chooses to sell, somebody is going to buy it, and the problem will not go away. The third point, which actually isn't really the importance of this appeal, but was merely an exemplar of this appeal, is that in this case we do have now a tenant-owned block with 18 flats. And so my client is the freeholder, but I have people here who simply live in the block. They happen to be the chosen directors at the moment. They're doing their best to manage this block. There is one difficult tenant, who is the applicant. Now, it will be said that she has some cause for complaint. My learned friend hasn't mentioned it expressly, but I think it's in his skeleton. She had problems with damp coming into her flat. But she sublets the flat. She hasn't personally paid any service charges for 10 years. If you want the reference to that, it's in the core bundle at page 147. And it's in the, I think it's the judgment of the First Tier Tribunal. Yes, it was the First Tier Tribunal decision in February last year, and it's page 147, paragraph 23. She hasn't herself paid any service charge since before 2011. What happened, as you know factually, is that not having paid anything for all these years, then my client, the landlord, then took proceedings before the FTT in respect of the arrears. And the FTT made a finding that they were all due. If you were to turn in the core bundle to the FTT decision, I took you just now to page 147. If you go back a page to page 146, and it's paragraph 19. The applicants previously made an application to this tribunal for determination of the reasonableness and liability for service charges payable by the respondent for 2011 to 2017. It's understood that these were also interim service charges. Hearing took place in July 2007. Short judgment, and then there was a judge, and then there was a chap with architect's qualifications. Respondent's no case to make or defend. Her representative made that clear at the hearing. The real thrust of her position is she wishes to make a counterclaim for damages or set-off. In the circumstances, the order for determination of the amount of service charges which are reasonable and payable is entirely appropriate. It is regrettable that her position was not clarified until the hearing. So, viewed objectively, you're dealing here with a tenant who certainly could have acted rather differently and reduced the level of the costs which my client was having to bear. And then there's an extra in paragraph 20. Prior to this, on the 21st of June, the tribunal had offered the respondent the option of having her counterclaim for damages determined by the tribunal, together with the 27A application under the pilot. By a letter, her solicitors declined the offer because the damages claimed were said to exceed the claim for service charges, and because under the pilot, the matter would be allocated to the small claims track. So she had legal advice. She made conscious decisions to set about a course of action which resulted in my client running up what were actually unnecessary costs. All that needed to be done, presumably, was some letter saying, my point is I have a set-off, but in relation to the service charges, I have no quarrel with them. Instead of which, you know, this is part of the cost.
Would that not constitute unreasonable behaviour which would entitle the landlord to get the costs in the tribunal?
Well, first of all, that's not an issue directly. My general appreciation of this is it's extremely difficult to persuade any tribunal that the no costs rule should be departed from in the way you're indicating. So just because someone's behaved wrongly isn't normally, I mean, the test is, the bar is a very high one. I haven't got any of the cases here on that point, but the bar is very high, and probably rightly so, because otherwise it would be a deterrent. If you make too much of an exception to the general rule, then you are deterring people from utilising the FTT, which is what it was set up for, to deal with issues. Not always issues that involve legal points, such as we've got here, but in fact, quite often you do find that lawyers and barristers come to be resorted to in these tribunals. And that the no-cost rule is so that landlord can come along armed with, you know, masses of lawyers, but the tenant can deal with the point, perhaps with a friend, knowing that, you know, the costs will not be borne in relation to that. But that's, of course, not to say that if, in fact, the tenant has wrongly challenged these fees, that the tenant should somehow finish up not paying somewhere. And that's, of course, partly why we're here, mainly why we're here. So that's just an illustration of my general points. Now I come to legal submissions on both the grounds 3 and 4, and I've got 6 points of varying length. My first point is, and my own friend and I disagree, I think, on how you approach Lord Neuberger's statement in the Arnold and Britton case. You were taken to Arnold and Britton and it's tab 24 in the Vulnerable Authorities, and the Maloney friend has been setting the bar for the construction of the lease that we're concerned with too high, because paragraph 23 at tab 24, and I have to say, sell a house, the dicta that I will be, I'm afraid, criticising shortly, that the sell a house is inconsistent in my submission with the approach of Lord Neuberger. And I've got various people that I will be citing in support of that. But 23, reference was made in argument to service charge clauses being construed restrictively, and that is sort of redolent of the sell a house. I am unconvinced by the notion that service charge clauses are to be subject to any special rule of interpretation. And then, so stopping there, this is just look at all the rules that you'll be so familiar with in approaching your task. Even if which not unnecessarily decided landlord may have simpler remedies, that's not relevant to the issue as how one interprets the contractual machinery. The origin of the Adwoa was in this judgment in Cadogan. What he was saying correctly was that the court should not bring within the general words of the service charge clause anything that doesn't clearly belong there. Now, I don't interpret that, but you will, obviously that's an exercise you will be having to consider, quite what is meant by the first bit and the second bit, because I submit that the overall decision of Lord Neuberger, with whom the other judges agreed, was that there is nothing special about a lease. I mean, I think it's very special because that's an area I practice in, but there's really nothing special about it. A lease is just a type of contract, just as a guarantee is or whatever else, and unless they're very peculiar rules, as there occasionally are, you apply exactly the same criteria. And that's all I'm inviting you to do, and will be inviting you. Not, however, as my learned friend was saying once or twice, perhaps more than once or twice, you know, you've got to be something like rather like a criminal test, you've got to be sure that it meant to include such and such. That isn't the exercise. The exercise is the all too familiar one, which I'm not even going to parrot, that you will be familiar with from the cases. So there is no restrictive meaning to service charge clauses, no special rule of interpretation. Now, I now come to the point which is one that I think will be I regard as important, which is I say it's not right to inquire into the state of the law at the date of the lease and then adopt a restrictive interpretation of the words used, because that is backwards and that is wrong. There can't be two constructions of the words, and I've given some examples in my skeleton, or our skeleton, of anomalies that could be created. We say, this is a lease, by the way, of 125 years. We say its words should be given a mobile rather than a static meaning. And that concept is taken from some cases that is actually addressed in Lewison's text in the bundle of authorities at tab 35. And we've got a selection of law from Lewison. If I can invite you in tab 35 to go on to paragraph 5.125. 5.125.
Thank you.
It's in section 15, date for application of meaning, perhaps I should take you actually to the preceding page where it's got section 15, date for application of meaning, because this is Lady Justice Andrew's point, but with my qualification. Presumption a contract must be interpreted at the date when it was made. Words must be given the meaning they bore at that date, and where the meaning is changed, evidence is admissible to prove the original meaning. However, in the case of a contract intended to endure for a long time, the presumption may be rebutted. So I'm interested in that qualification. And if we then go over the page to 5.125, the principle of contracts to be interpreted at the date when it was made doesn't necessarily freeze the meaning of its words. The court may choose between a static meaning and a mobile meaning. Thus, a right of way for carriages granted in the 19th century can encompass motor vehicles, even though they were unknown at the date of the grant. And then there's other examples given. If you drop down to the bottom of the page, you'll see there's a reference to Shebell Enterprises and Hampstead Garden Suburb. The Court of Appeal interpreted a covenant for quiet enjoyment in the light of changes in the legal structure following the grant of the lease, and in particular the implementation of a scheme of management under the Leasehold Reform Act 1967. In the case of a long-term contract, parties often express themselves in broad, flexible terms in order to enable them to adjust to changes in circumstances. The courts will recognise this kind of contract and adopt a flexible approach to interpretation, though loyalty to the text of the contract remains the first principle. And then there's some more examples. What I wanted to do was take you to the decision of Shebell itself and also a decision of the Deputy President of the Upper Tribunal. So if we define Shebell, that's in tab 21 of the bundle. And you'll see on the second page, this hasn't been barred, it hasn't got a little line on, but if you look at H6, it was an appeal against the decision of Mr. Justice Henderson and his consequential order where he dismissed the application of the appellant company, Shebell, for an interim injunction to restrain Hampstead Garden Suburb Trust from granting consent for development of a property in the suburb, and upon the cross-application of the trust, he dismissed Shebell's claim. The facts are set in the judgment of Lord Justice Kitchen, and he sets out that issue. If you go on to his judgment page, page 116, paragraph 1, an appeal against the judgment of Mr. Justice Henderson, his consequential order, and that's more or less a repeat of what I've just read to you. And then in this case, the lease was in 1931. So if you look at paragraph 9, you'll see Shebell owns the house and land at number 3 Green Close, NW11, under the terms of a 999-year lease granted in January 1931. It then got sublet and that kind of thing. Now, when the case got on appeal, there was an argument about this very point, about how you looked and whether you looked at later legislation. If you go on to paragraph 28, the appellant was represented by Mr. Jonathan Seatler, and the parties represented, as they were before the judge, Mr. Jonathan Seatler appearing on behalf of Shebell, Mr. Weeks on behalf of the trust. Mr. Seatler developed the following 4 main arguments in support, and we're interested in the first one. First, the judge fell into error in construing the lease by reference to a later legislation, namely the 1967 Act. It is, he said, axiomatic. An agreement must be construed as of the date it's made. Further, in 1931, the parties to the lease can't be reasonably envisaged that the freehold reversion would ever become vested in a public body, which had public duties to perform. Moreover, there was never any basis for concluding that the 1967 Act or any other enfranchising legislation was meant to dilute the value of the quiet enjoyment covenants in leases, which remained outside its scope. In these circumstances, it was illegitimate for the judge to override or circumscribe Shewell's rights on the basis of the adoption by the trust of a supposed public law many decades later. And then that is then addressed. If you go on to paragraph 36, there is a passage which is flagged, which is important. It's entirely correct to say an agreement must be interpreted in the light of the circumstances pertaining at the time it was made. But that doesn't mean that the parties didn't anticipate a particular factual situation which subsequently arises. The agreement doesn't apply to it. In such a case, the question to be considered is what reasonable parties should be taken to have intended by the words used in the agreement in relation to the event which they did not foresee. And then there's a citation from Lord Justice Chadwick. It's not to my mind an appropriate approach to construction to hold that where the parties contemplated event A and they didn't contemplate event B, their agreement must be taken as applying only in event A and cannot apply in event B. The task of the court is to decide in the light of the agreement the parties have made what they must have been taken to have intended in relation to event B, which they did not contemplate. It's an artificial exercise because it requires them to be attributed, they're to be attributed to the parties an intention which they didn't have as a matter of fact, because they didn't appreciate the problem which needed to be addressed. But it's an exercise which the courts are willing to undertake for as long as commercial contracts have come before them for construction, an exercise which requires the court to look at the whole agreement which the parties made, the words they used, the circumstances that used them, and to ask what would reasonable parties be taken to be intended by the use of those words in that agreement. And then he says, and so he then applies those general principles in the context of that case. And I put my submission like this. I say that you should not look at a particular state of statute law at the date of the lease, and that's an inappropriate inquiry. And all this interesting information you were given that this case related to the lease in this and the lease in that, and then of course you were given examples about how you could then go down the wrong road if you did that, because there'd then be a lease renewal. All that is dangerous territory. My submission is in fact in line with the Vice-Chancellor's comments in near the end of the bundle of authorities in the Ashraghi case, which is tab 32. So Martin Roger QC, who's the Deputy Chamber President and has dealt with many of these type of cases, the passage that is pertinent, and I see it's flagged up by both.
Sorry, which paragraph are you in?
Paragraph 73.
Sorry, but I should have said which tab are you in?
Oh, sorry, tab 32.
32.
32.
Thank you.
And what I noticed is, so Mr. Ashraghi looks as though looking on the front page, he was acting for himself, and counsel was appearing on behalf of the respondents. And so 73, Mr. Ashraghi argued in 1973, when the leases were entered into, parties would not have intended the costs of proceedings to recover unpaid service charges, which at that time would have been conducted in court, would be an expense recoverable through the service charge. They also included a covenant by the leaseholder at clause 2.9, which covered certain legal costs, but not the cost of tribunal proceedings. Referring to United Pension Trustees, he argued that the absence of an express provision making leaseholders collectively responsible for legal costs of proceedings against one of their number indicated an intention that no such cost should be recovered under the more general provision. I see the force of both those points. But the lease was for a term of 99 years, and in paragraph 11 of the second schedule, the parties used language which is intended to cover unforeseen expenses in the provision of any service, matter, or thing properly and reasonably provided or done in the interest of good estate management. The question is whether the costs in question fall within that language. The language used in unit trustees was significantly different. So the approach, at least in that case, of that judge was to look at the language used. You obviously then have regard to the particular costs that you're concerned with, but you will tie yourself in knots. I respectfully submit a very non-legalistic submission. If you try and go back in time and then ask yourself what was the statutory code that was in existence.
There was passing through my mind a comparison with the United States Constitution and the right to bear arms. Supposing there to be a right to bear arms, back in the 18th century they didn't have in mind machine guns, but nevertheless they are arms. But leaving that irrelevant point to one side, the way in which, or a way in which, this argument can be deployed against you potentially damagingly is to say, back when this lease was entered into, the parties would have known that following the service of the Section 146 notice, there would be proceedings in respect of which cost orders could be made and where payment of costs could be made a condition of relief from forfeiture. Therefore, they wouldn't think it necessary to provide for the costs of proceedings in the lease. Now, that's not construing the lease exactly by reference to the statute at the time. It's recognising that the statutory structure at the time might have led them to think that it wasn't necessary to provide for the costs of proceedings.
But the difficulty with that, my lord, is where we have a long lease, in this case 125 years, are the parties to have presumed that there would have been no intervention by Parliament in that period of time. And if they were asked, honestly asked, when they were entering into that lease, do you think that Parliament might intervene in some way to regulate some parts of this lease? The honest answer would surely be, that's certainly a possible event, if not a likely event.
But that's not really, with respect, the right question. The right question is, would the parties, would the objective intention of the parties be that were Parliament to require a landlord in future to incur certain legal costs before he could serve a Section 146 notice,
Yes.
that those costs should be recoverable by the landlord in circumstances where the tenant couldn't recover them if the boot was on the other foot? That's really the question. And if the answer to that is obviously yes, then you're home and dry. But if the answer to that is not obviously yes, you might be in difficulty.
Well, my learned friend, I say you don't need to, you just look at the words. You don't have regard to a particular statutory regime, either one known at the time or one that's unknown. And yet the comments in the Shebell case would seem to indicate that you must look at the wording having regard to events that weren't in any way in contemplation at the time. So it's no good, it's an entirely, how's it put, it's an entirely artificial exercise to ask what might the parties have done, because they haven't. All you can do is say, you've entered into a lease for 125 years that has a certain regime whereby landlord is going to carry out certain obligations, and then the tenant is going to contribute to those by way of service charge. And then in addition, there will be certain tenants' covenants as to paying various expenses and costs. And then, but then you can't ask the question at the date of the lease, does this cost or does it fall within or without? Because that's entirely artificial. All you can do is ask it by reference to the words used. And I emphasise the words used, and I'm just concerned that my learned friend kept re-emphasising that you have to be in some way sure that somebody entering into the lease would have come to that conclusion. I don't find that within any of the principles of construction. Principles of construction don't require you to have two possibilities and you rule out one possibility simply because you're not sure. What you have to do is you have to weigh up all the possible constructions of the words used and then come to your decision, not on some kind of criminal burden of proof, but just on what you do in a civil case. And so that I perceive could be a really important point. And the fact that it's featured intermittently in decisions of the Upper Tribunal, and sometimes the Upper Tribunal say, we're not interested in going down that road. Sometimes they are interested, and sometimes they don't think, somewhere in the middle. That this strikes me, may not strike you, as being a point of some significance going forward, where, as you do have with leases, with residential leases, an increasing amount of statutory intervention that wasn't there and isn't there in other types of area. It's almost a quintessential thing, but with a lease, it's very long. I'm not an expert in other areas, but whether there are other long-running contracts for many, many years, where also Parliament has intervened at different times, and whether there's any guidance there.
Well, I think there is some in insurance, but I think it's sufficiently far away. It's a case that's actually referred to in the passage in Lewis and you took us to.
Yes.
Can I ask a question which may be completely irrelevant, and I may just be getting befuddled? The distinction is being drawn between the statutory changes, when there was a regime which allowed people to recover and so their costs, and so it said, well, that's fine because everybody knew they would recover their costs one way or the other by the order of the court or the tribunal.
Yeah.
And a latter day non-cost bearing regime. But under the cost bearing regime, you might have irrecoverable costs of a landlord, and you might even have a landlord incurring liability for the costs of the tenant.
Yes.
Well, what does the contract say about that?
Well, I am going to make some specific submissions a little later about the words used of the two covenants that you're concerned with. But you're quite right this isn't a binary question where you've got a lease with no statutory intervention and then you've got some statutory intervention later on, because even when there was no statutory matrix in existence at the time of a lease,
this question could arise.
These questions could arise. And you would think that landlord, unless it's acting in bad faith, would expect to be able to recover legal costs.
Or you may think that the contract doesn't provide for it.
Yeah.
So can I just focus on, take the case where the landlord sets about forfeiting under the old regime.
Yeah.
And leave aside the case where actually his ground of forfeiture doesn't work, but he pursues it and gets to court or not, I don't know. He'd expect costs to be paid as a condition of relief.
Yes.
So there he wouldn't expect to have a shortfall.
Well, in the case where the landlord establishes forfeiture, but the tenant escapes losing the lease by means of relief, the current state of the law is that normally the landlord recovers on an indemnity basis. Of course, that's not the same as a solicitor and client basis, so there still would be a shortfall.
Yeah.
Although I'm diverting, since obviously the language used is quite important, can I divert to then look at the clause which is the subject matter of ground 3, only because we're talking about section 146 notice and the like. You can find that in the supplemental bundle, isn't it? It's page 18. Now, to some extent, I'm anticipating things I'm going to say, but since I'm going to say them anyway, it's subclause 5, as we know. It's to pay all costs, charges, and expenses. So they're very wide. All costs, charges, and expenses, all those words, including solicitors' costs. So we know legal costs are in play. Incurred by the lessor for the purpose of or incidental to the preparation of the service of a notice. Now, my learned friend submits that that's the cost of a piece of paper. Now, but read on. Notwithstanding, forfeiture may be avoided otherwise than by relief granted by the court. So I've read these words, although they're quite commonplace within a clause like this. So forfeiture may be avoided otherwise than by relief. So the relief, you've got the court order to deal with the question of costs. But this clause is supposed to be dealing with costs. Notwithstanding, relief may be avoided otherwise than relief. So is it not, I suggest, not just concerned itself with the very limited costs, but those costs where forfeiture may be avoided. So, for example, the tenant remedies its breach. You get to the stage where you've served your Section 146 notice, and then the landlord comes up and says, it's not the landlord, the tenant says, right, here's all my arrears.
Yeah, you've already incurred your costs of preparation and service of a notice. So the fact that the tenant has remedied the breach and those costs have effectively been thrown away, you're still able to recover them. The fact that the tenant has done what the tenant has done, that doesn't stop you getting your cost back. But there's still costs that are incurred for the purposes of or incidental to the preparation and service of a notice under Section 146. So there's got to be a link between the costs and the preparation and service of the notice.
Yeah, well, that's correct.
And at that stage, it doesn't seem to me to cover costs which are incurred after the service of the notice in enforcement of that notice.
Yes. Well, happily, that's not an issue in this
No,
appeal.
but it may actually be pertinent to the issue in this appeal.
Yes.
Because looking at it from that perspective, I mean, I see entirely what you say about costs. If Parliament now says, well, in order to prepare and serve a notice, before you do it, you have to incur certain legal costs, then that's a wide enough expression to cover those legal costs. See the force of that entirely.
Yeah. And indeed, you rightly anticipate my submission. My submission is this is as plain as a pikestaff.
Yeah.
You know, this isn't a case for any. Not that I say we're weighing up ambiguities and things. Yeah, this is a classical case where the costs of going off to the FTT are recoverable when we know, and this was a finding by the tribunal, that I'll just find the reference to that. Yes, it's in the core bundle, page 103. Just after the page 102 has got the claim for costs under the fourth schedule in Judge Cook's judgment, and we've got the Section 146 is set out, and we've also got conveniently she's flagged up in paragraph 37 the fact that the surprising decision about Section 146 is required for service charges even if they're recoverable as rent. Then you've got the Housing Act, and then the finding she makes, 39. The landlord cannot forfeit a lease for non-payment of service charges until the FTT has determined that the service charges are payable, nor even serve a Section 146 notice in preparation for forfeiture proceedings. So that's her decision, which I don't understand to be in any way challenged by my learned friend. So if it is the case, which it is, you can't serve a notice without having gone to the FTT, then what are all costs, including solicitors' costs, incurred by the lessor for the purposes of service of a notice? You just pick up those words and we're four square within it.
You don't need to rely on the word incidental, do you? I mean, we've had an interesting debate about what's meant by incidental, but you don't need to go there. It's for the purpose, you would say.
Yes, yes. That's my primary submission.
Yes. It's
Anyway.
a bit difficult to regard them as incidental costs. They're either within that. They're either costs which are incurred for the purpose of the service of a notice.
Yes. Yeah. Anyway.
And you say that, just to make sure I'm clear on your submission, that although at the time that the lease was entered into, those types of costs would never have existed.
Yeah.
Because all you need to do would be instruct a solicitor to draw up the notice and pay his bill.
Yeah.
The word costs is wide enough to encompass legal costs of the process because the parties are far-seeing enough to say, well, there may be all sorts of changes to the regime as to how you serve notice and so forth. But as long as the costs can be linked to the service of the notice under Section 146, they're recoverable.
Yes.
It's wide enough.
Well, it's sort of doing a little blue pencil rule or something like that, which is sometimes held for construction, sometimes doesn't. You go through and you just flag up some of those words, and you're there. Because this has actually got costs at the beginning, but in case there's any doubt that that could include legal costs, it's got in brackets including solicitors' costs. So.
It's simply got to be costs for the purpose of the preparation and service of a notice under section 146.
Yes, that's the words that the parties have chosen to use.
That's your blue-lined words, as it were. Yes, your underlined words.
That's right. Now, I'll come back to that. I've taken a slight diversion, but that's merely giving an example of where I got to in my submissions. Let's see where I've got to now. My third point, which I can probably take very shortly, is it's wrong to construe the words in one contract by comparing them with the words in a different contract. My learned friend helpfully took you to Rees and Peters and the passage in the judgment of Lord Justice Sedley. There's actually a similar comment made by the Chancellor at paragraph 10. I'm not sure I need to take you to that, but if this is a concession, so be it. But it may be that one of you will ask me this question anyway, which is, Judge Cook seemed to have approached part of her exercise by some kind of, let's look at these words, let's look at that word, and we're more or less in the right territory, and therefore that I'm not here to support that particular aspect of her judgment. Indeed, my submission is the reverse. You look at each contract as it is, in accordance with the established principles.
Unless it's identical.
Yes, although even if the words...
On your submissions, if every single tenant here has got the same contract, their contracts may mean something different depending upon whether they took over the lease before or after the change in statute.
Well, yeah, that would be a consequence of my learned friend's submission, because you get some developments where you've got the old leases, and then later on there's been enfranchisement, and so some people have got old leases and some people have got enfranchised leases where they've added another 90 years on, and the wording is the same. I'm not proffering a solution, but you've got the same development, you've got the same words. Do you actually arrive at the same conclusion? I'm not actually entering into that territory. I'm more in the territory of different developments. You said the same wording. If you have different developments with leases granting at different times with the same wording,
could have different meanings.
It might have different meanings. That's not hypothetical. I actually had a case last November in the FTT where I had identical words, and my opponent from a very well-known property chambers was arguing nonetheless that those words were to be given a different meaning in a different case. So anyway, the exercise is ultimately you have to look at this case and the words used. So that's actually my fourth submission, so I don't need to go now. Now my fifth submission does...
The fourth is you have to look at these words.
Look at these words, yes.
Yeah.
The fifth is to reflect on Lord Justice Taylor in Cellar House. My submission is the dicta of Lord Justice Taylor in Cellar House must be read in the context of the case, and they do not establish any general principle. You'll see in a moment, I actually went so far, probably too bold, to describe those words now as a heresy. I didn't carry the Vice President with me on that, although he did agree that they're too often cited and that they aren't a general principle. And I know that Cellar House, and I'm going to show you why the recent citation of Cellar House by this court doesn't mean that they have said that those are now, there's now some kind of general rule to be applied. So I need to take a moment or two with you to show you why I say Cellar House dicta are but dicta, and they must give way to the words used and also give way to what Lord Newberger had to say in his subsequent case. So what I was going to do is I was going to look at the four cases chronologically. First of all, Cellar House. You've got that in tab 10. If I find it. It's really quite a... I mean, it's gained far more currency than you would have thought of done, because it was a very, very ordinary case with somebody who had a bit of disrepair to a flat, And anyway, it comes in front of Lord Justice Dillon, and there's an appeal under quantum of damages, and there's a cross appeal about the recovery of legal costs from all the tenants by way of service charge. And I think you were taken to the words used, which are different from ours, at the bottom of page 154. And then you were taken to the comments about whether those words caught the legal costs in question. And you were taken at top of page 156 to Lord Justice Dillon saying, I have had certain hesitation on this point. In the light of the argument in relation to the position where solicitors are instructed by managing agents, it doesn't appear from the evidence whether that was actually the case. On the whole, however, I have come to the conclusion the judge was right that the fees of solicitors are outside the contemplation of the limbs. So that was a sort of very narrow-based, hesitating conclusion on particular costs in different wording. And then Lord Justice Taylor says, I agree. Now, if I was being a little mischievous, I might say, is he agreeing with the certain hesitation? He's agreeing with the conclusion, let's assume. I add only a few words on the issue whether legal fees can be included in the service charge under this lease. Nowhere in the clause is there any specific mention of lawyers, proceedings, or legal costs. So that's a big point of distinction here. No lawyers, no proceedings or legal costs. The scope of J1 is concerned with management. Then you've got maintenance, safety, and administration. On the respondent side, tenant paying his rent and service charge regularly will be liable versus the service charge to subsidise the landlord's legal costs of suing his co-tenants if they're all defaulters. I'd be required to see a clause in clear and ambiguous terms before being persuaded the result was intended by the parties. So this is a narrow concern he's got, that somebody who is totally straightforward lessee who otherwise pays all their service charges on time, the Lord Justice Taylor's hesitation is in saying, well, the non-defaulters should be subsidising the defaulters, and there would need to be, he says, clear and unambiguous terms. Now, that was specific to this case, one paragraph, and yet lessees and tenants up and down the land picked on this, and they've run with it in a number of cases, but not with then later on with discouragement, I should say, because the next case that comes along is Hyperion, and so that piece of cellar house, that's the next tab in the bundle, and Hyperion, you'll notice, I think I mentioned this in my skeleton, is one with very notable counsel. If you turn to page 198, you'll see that Mr. Berry was counsel for the landlord, and Mr. Newberger was counsel for the tenant. And you've got Lord Justice Peter Gibson saying, an appeal from part of the order made by Bruce Maleverer, sitting as a deputy official referee, the dispute before us relates to the incidence of the defendant landlord's legal costs incurred in litigation against the plaintiff's tenant, in which the plaintiff was largely successful. Is the tenant contractually liable to pay a share of the costs as part of the service charge payable by him? So the plaintiff's, should the court interfere with the order for costs made by the judge? And you then get, pick up the relevant point. Yes, the first issue about landlord's costs is addressed at page 200. And if you drop down to, there's a quotation with the provisions for the costs, and then Schedule Act. Before us, Mr. Berry, who didn't appear below, has relied on the words used in recital 1K, and in particular, and then the words are read out. Defendant says the alterations, which hadn't been approved by Camden, exposed it to the risk of action being taken against it by Camden for breach of 2 covenants by the tenant in the head lease. One is clause 217, blah, blah, blah. Right. The judge held, for reasons similar to those advanced by this court in Cellar House, the costs of the defendant's forfeiture claim and of the plaintiff's claim for relief could not properly be regarded as within the proper cost of management of Broadwalk House. In the Cellar House case, the question was whether the landlord could recover as part of the service charge legal expenses incurred by it in recovering rent from the other tenants. The service charge was based on the expenditure incurred by the landlord in carrying out the obligations, and then there's a quotation of some of the words. Lord Justice Dillon, with hesitation in respect to the position where solicitors are instructed by managing agents, on the whole came to the conclusion the judge below was right in his view that the fees of solicitors and counsel were outside the contemplation of the provision I've quoted. Lord Justice Taylor pointed to the absence from those provisions of any specific mention of lawyers, proceedings or legal costs, and said the scope of the provisions was concerned with management, maintenance, safety and administration. And then there's the quotation. I am not able to derive any assistance from that case. The language of the relevant provision is very different from that in the present case. And then they go on. And so that wasn't significant. While I'm on this case, at some point, in fact, I'm going to come onto it as my 6th point, so I'll come onto it soon. I was going to be mentioning that although I've said you don't interpret the lease by reference to the statutory regime at the time, my learned friend was submitting to you that you should adopt a very narrow approach. And I think he was saying that because he's inviting you to say that tenants shouldn't find themselves liable to pay costs and it could be used as some kind of weapon against them or something of that kind. Now, Parliament is conscious, just as Parliament has introduced protections for tenants in steps that landlords must take in order to recover service charges and other things. Equally, Parliament is alive to the fact that those costs might redound on tenants. So Parliament has also introduced legislation that protects the tenant against certain costs. Not mentioned this morning, but you probably picked up from reading some of the skeleton, but I think it's important I should stress that what I'm referring to here is Section 20C. Now, Section 20C in its original form is set out here in Hyperion. Landlord and Tenant Act Section 19 prevents the landlord from recovering so much of a service charge as consists of costs unreasonably incurred. Section 20C, introduced in 1987, goes further. And then there's a quote from it. A tenant may make application to the appropriate court for an order that all or any of the costs incurred or to be incurred by the landlord in connection with any proceedings and not to be regarded as relevant costs taken into account in determining the amount of any service charge payable by the tenant or any other person or persons specified in the application. And the court may make such order on the application as is just and equitable in the circumstances. So Parliament has appreciated that stepping in one way, creating certain protections for tenants, might cause the landlord to incur greater costs, and obviously recognises that the landlord will seek to recoup those through the medium of the lease, either directly from the tenant or from all the tenants through the service charge. So what it's done, and you see this happened in 1987, so same time that these other changes happened, it introduced Section 20C. Section 20C is still there, although in a slightly expanded form. And you know that 20C is in play in this case, because my learned friend mentioned it to you just before the short adjournment, that there was an application for 20C, the appeal of which it isn't, well, in a way it's before you, but I mean, you're not going to be considering it. But perhaps now is a convenient moment for me to say, I agree with my learned friend's proposal that the time for that should be 28 days after you handed down judgment in this case, because there is learning on 20C, you won't be surprised to know, and who knows, depending on what happens in this case, you might be troubled dealing with that at some juncture. But the basic proposition, and that's why I'm mentioning it to you here, is that it's not all one way. You mustn't think that your decision you should anyway slant your decision on construction in favour of the tenant, because the tenant has another remedy specifically given to it. And sometimes the courts do use the existence of some parliamentary or some piece of statute to weigh in the balance, but in this case you don't need to do that because Parliament has intervened. So you can do your exercise, your construction exercise, as if this was a commercial lease rather than a residential lease. So I've mentioned Hyperion. I've added on this bit about 20C. Now, then my learned friend has relied on West India Quay, and that is a very recent decision. He only took you to the reference to Cellar House, but I do want to show you a little bit more about West India Quay. Tab 33. If we just glance at what the case was about, it raise it because it was a bad landlord doing nasty things. This case, it wasn't anything like our case. This appeal raises two unrelated but significant main issues concerning recovery by the landlord from tenants of residential property held on long leases, service charges, and legal costs incurred by the landlord in litigation with the tenant. The first issue was the interpretation of 20B, yet another one of the provisions, but this one we don't have to be troubled with. Number three, the second main issue turns on the construction of three separate cost recovery provisions in the leases, in reliance on which the landlord seeks to recover from the tenant a proportionate share of the landlord's own legal costs incurred in the present litigation with the tenant, which started in 2040 and has been vigorously contested ever since. And you'll see the appellant landlord is W1 WIQR, the landlord, and the respondent, you look at the end of paragraph 4, is East Tower Apartments Limited, ETAL, or the tenant. And then if you go, then there were lots of issues over the problem with supply of, I think it was electricity. Yes, electricity and other things through the meters. And if you go to paragraph 8, you'll see it says most of the problems only came to light after ETAL, so the tenant, issues proceedings in 2014 in the FTT taking issue with a number of aspects of the utility costs which had been charged. The proceedings led to a 3-day trial before the FTT. Shortly before the hearing, the landlord conceded it had wrongly included commercial rate VAT and climate change levy in the unit rates for heating, cooling and domestic hot water, and had further added VAT at the residential rate, thus overcharging the tenant and all the other lessees by about 26%. The landlord also admitted some other overcharging, but a number of issues remained in dispute and were the subject of the trial. Following an appeal to the Upper Tribunal, which resulted in the Upper Tribunal decision, certain matters were remitted to the FTT for determination. Further hearings then took place before the FTT in December and March 2019, leading to a final decision after review. One of the issues dealt with was the recoverability of some standing charges. The FTT held they weren't recoverable because they'd never been contractually valid demand for them as service charges, and it wasn't open for the landlord to reallocate them as general service charges. And then there were more decisions, and then, so that's all sketching the background, and then you then got the decision by the Court of Appeal on issue 1, we're not concerned with that. Issue 2 starts at paragraph 43, and you see what was involved if you look at paragraph 43. In the cost decision, the FTT explained that when the case was remitted to it following the 2016 UT decision, parties asked it to rule on several matters, including the switch charges. The FTT's decision on all those matters was contained in the 2019 decision, finalised in June 2019. Meanwhile, during the course of 2018, the landlord sent various demands to the tenant in respect of the landlord's legal fees incurred in the proceedings to date. Those fees were said to amount to a little under £500,000. So remember, this is litigation begun by the tenant in order to find out what it really owed for all these charges, and it seems to have done very well in the litigation. And we've then got, so that's all the backdrop. So I'm not going to read all this in the meantime. But if we go on to the clause, so a couple of the other clauses are ruled out. We get to paragraph 68, I think is the clause that's relied on. The third provision on which the landlord relies forms part of the machinery in Schedule 4 to the lease containing the residential common parts service charge. Tenants required to pay a percentage of gross annual expenditure, defined in paragraph 6 as the aggregate of all cost all cost expenses and outgoings, whether properly and reasonably incurred during the financial year in or incidental to providing all or any of the services, all costs properly and reasonably incurred by the lessor during the financial year in relation to the additional items. So it's very generic sort of language. And then at 71, it is apposite in this connection to have regard to the decision of this court, where it was held that the generally word provisions in service charge machinery didn't include litigation costs incurred by the landlord. And then we've got Lord Justice Dillon had some hesitation, Lord Justice Taylor agreed, and then you've got the quotation. So what I read when you've got the agreement with that, I consider mutatis mutandis, the same points may be made about the provisions with which we're now concerned. I can't see any error in the approach of the Upper Tribunal. And and they say right at the end of 72, it's enough for me to say that in the present case I'm satisfied the Upper Tribunal came to the right conclusion on the point for the reasons it gave. Now, what we say about this case is as following, and I think I jotted down 4 points. that I wanted to make. Yes. First point is the factual background is very different from this case. The tenant issued proceedings challenging the utility costs, and it transpired the landlord was very much in the wrong.
But that doesn't make any difference to a point of construction.
No? That's right. That was the point.
That's a jury point.
That's a jury point. Secondly, and again this may be a jury point, the landlord then tried to recover nearly £500,000.
Well, he also tried to do something fairly similar in Hyperion, although perhaps the merits were slightly better based, but ultimately he lost under 20C, didn't he, the landlord?
Yes, which is, I regard as a point in my favour, because in Hyperion they weren't, as I perceive it, they weren't having to stretch the wording because the Court of Appeal knew that they had a backstop of 20C, regardless of their construction. Anyway, perhaps the last 2 points are not jury points. The third one is very different wording between the covenants in our case and the covenants in this. And lastly, and this is my submission, I say cellar house wasn't cited as a general principle. What it's cited as is the sentiments expressed happen to be the same sentiments as are the sentiments expressed in the judgment of Lord Justice Henderson. I've tried to find out, as far as I can see, this case hasn't been reported yet. So I don't know, other than the cases that are actually mentioned in the judgment, which were cited to the court. So I don't know, for example, whether Arnold and Britton and the famous passage of Lord Newberger was cited. And I don't know whether Hyperion was cited. So what I say about this case is that you get no more out of number 1 West India Quay other than you would get out of cellar itself. You will evaluate what you feel that's really meant by that. Are those just comments made by Lord Justice Taylor pertinent to the facts of the case before him, and which similar sentiments might appear in other cases? Or is there some kind of more specific principle? And I say there isn't some specific principle, and in relation to that is my last passage on this 5th point, which is the Gayfords case, which is tab 26. Now, you've already been taken to the Gayfords case, and there's just one passage I wanted to take you to, paragraph 39. This is another decision of Martin Rogers, the Deputy President. And this is the bit where I've gone a bit too far and sort of called something a heresy. Cellar House has provided spaces...
Sorry, was it 39, did you say?
39, yeah.
This is the Deputy President saying the remarks have often wrongly been elevated to a statement of principle.
That's it.
He then goes on to say it shouldn't be thought controversial that clear and unambiguous terms are required to impose what he regarded as an onerous and unusual payment obligation.
Well, I don't have any problem with those, because what I'm saying is not that the costs we're trying to recover are not an onerous and unusual payment obligation. Indeed, they are the payment obligation that should be expected to be recoverable from a lessee, rather than the reverse. So that's
even if the landlord has lost.
Well,
that's the acid test, isn't it? Because on your construction, it must mean win or lose. He gets his costs.
Yes, and isn't that what they said in Hyperion? In Hyperion.
Well, they did on the language of that particular clause.
Yes, but and they weren't deterred. But what they were able to do was use 20C to come to the rescue. So,
but you have to ask whether on the language of this particular clause, that was what the parties' objectively ascertained intention was. In other words, circumstances where you enter into litigation of this nature, whether you're successful or not, you should get your costs back.
Well, you're referring to the subject matter of this appeal, Melanie. I mean, when I look at Hyperion, which is tab 11, the submissions, it looks like this was one of these rare cases where on construction Lord Justice Newberger lost. It's the top of page 202.
He was counsel at the time, I think.
He was counsel, yes. Yes. Now, he was against Simon Berry, and at the top of 202, I see the force of that submission, but I'm unable to accept it. Mr. Berry, in my opinion, was right to submit. The definition of the landlord's cost was not drawn by reference to cost of successful, as opposed to an unsuccessful action taken by the landlord in its management. All costs properly incurred in the reasonable and proper management of the property were included, and they will include costs of unsuccessful proceedings properly brought in managing the property. Throughout, the defendant was acting legal advice, blah, blah, blah. So it finishes up. They're of the view that the costs would be incurred. That's when you get to 20C. But then, as you've probably seen reading ahead, when you get to page 203 in the middle of the page, it's unattractive a tenant who's been substantially successful in litigation against the landlord and who's been told by the court that not merely need he pay no part of the landlord's costs, he has an award of costs in his favour, should find himself having to pay any of the landlord's costs through the service charge. In general, in my judgment, the landlord should not get back through the back door what has been refused by the front. So that's then become one of the principles that tends to get used under 20C. But because of 20C, this is the proper intellectual approach. What does it mean? But we've got a statute here that can come to the rescue of the tenant.
So well, tell me if this is an incorrect summary. The words you find in paragraph 5 of the fourth schedule, referring to costs, charges and expenses incurred for the purpose of a section 146 notice,
Yes.
are perfectly apt to refer to the costs relating to steps that were subsequently introduced by Parliament, but which needed to be taken in those circumstances before a section 146 notice can be served. And while the parties may not specifically have had in mind that parliamentary intervention, there is a sort of matching parliamentary intervention under which any prejudice to a tenant can be mitigated.
Yes. Or to put it another way, I mean, you've got the language using the words, rather thinking about Lady Justice Andrews on this different point to do with rents. If you apply the words, I'm home. So not to disapply the words, you've got to have some reason to do it. My learned friend has come up with it. He says, "Oh, sell a house is against me, or it's against me, and the statute's against me, or something." But looked at logically and properly, that's.
Well, what he says is that costs for the purposes of or incidental to the preparation and service of a notice don't include costs of proceedings, because costs of proceedings are something completely different, and there's no mention of proceedings.
Well, in some of the other covenants, you have proceedings, but that, of course, was at a time when you did have proceedings in the normal sense.
But they were different proceedings. They were proceedings for enforcement.
These depends what you call proceedings. The statute requires you before that was that paragraph that I've still got open here, paragraph 39 of Judge Cook's judgment, that you can't serve the section 146 notice without getting the FTT to rule. So this isn't the case. You would still have the proceedings. This is a preliminary step.
Yeah, what you say is that the party's objective ascertained intention is that any charges, expenses, including paying lawyers, which are necessarily linked to getting your 146 notice served, are covered. It's wide enough to cover anything like that, and if it so happens that the process has changed over many, many years' time because Parliament has included some extra hoops that you have to jump through,
Yes.
then the hoops that you have to jump through are necessarily envisaged as being encompassed by that, because the language is wide enough to cover all preliminary steps that need to be taken in order to get your notice.
Yeah.
That's really the essence of the argument. And you say the language is clear, it's unambiguous, it doesn't say anything different, and we should just follow the language of the provision.
Yeah.
Can I just stop one eye? Section 20C applies to this, presumably. Section 20C is expressed as applying to service charge, and this lease, there's so to speak a separate service charge provision, but does Section 20C bite on this bit as well?
Well, it was decided by I think it's the 69 Marina case that in our case the service charges are not recoverable as rent. So they are, but even if they were recoverable as rent, they would still be required to go through this process of going to the FTT.
Sorry, I'm on a slightly different point.
All right.
So just in terms of section 20C,
Yes.
under which things can be disallowed for service
Yes.
charge purposes.
Yes.
Is this a service charge purpose, so to speak? I mean, this isn't. You have to contribute so much in common with all the other tenants to a cost. This is, if I incur this cost, you have to pay me. Does section 20C apply?
My understanding is yes. The text of section 20C has been expanded, and we've got it at near the beginning of the vulnerable authorities. In tab 2, it's the 1985 Act.
Yeah.
It's been slotted in 20C. So it's been moved around. Or any of the costs incurred proceedings before the court.
Or tribunal.
I mean, the bit I'd just like to be clear about is it says not to be regarded as a relevant cost to be taken into account in determining the amount of any service charge. And is the definition of service charge wide enough to catch the obligation to pay that would arise under paragraph 5 of the fourth schedule?
Yes, well, we've got.
So I'm really sorry to hesitate to interrupt. The answer to the question is no, it's not, because the provision is dealt with elsewhere. It's dealt with in paragraph 5A of Schedule 11 to the Commonhold and Leasehold Reform Act.
Sorry, paragraph 5.
Paragraph 5A
of Schedule 11.
Schedule 11 to the Commonhold and Leasehold Reform Act. And you'll find that in tab 4. Tab 4 that starts with section 168. On the third page you have Schedule 11.
Yes, you've
Yeah.
helpfully
Third.
redlined it.
And then on the third page you have section paragraph 5A. Take a moment, you'll see that.
So is that to the same effect?
It's to the same effect,
Yes,
but that's it's section 20, as you rightly say, applies to a service charge. This applies to administration charge. The 146 clause is an administration charge.
Yeah, I follow. Thank you very much.
Well, I'm very grateful to Melania Friend. Very fair. Right. So it doesn't matter how you dress up the legal costs, you still have to encounter section 20C or its equivalent. So that was my sixth and final point on the general points. So I can now go relatively quickly to the two separate grounds. Ground 3, I think I've really my submission on ground 3 you already have, so I've made it. The only other notes I've got down here is you've got this contrast between contract real and 69 Marina. You've been taken to some of the wording there. We say 69 Marina is. We've addressed this actually in my skeleton of paragraphs 42 to 49. This is my backstop, so this isn't my primary case. So I will adopt what we said in our skeleton of 42 to 49. The only point I wanted to amplify was in relation to the contract real case, where I understand my learned friend wants you to find that 69 Marina can't be followed, or you can decline to follow it because of that case. That is tab 12 in the bundle of authorities. And in the reasoning of Lady Justice Arden, we had paragraph 36, where she just says the natural meaning of the word incidental. So that's just a dictionary type approach. And then she has, secondly, paragraph 37 onwards, she then looks at some cases, which in fact are cases to do with incidental in the statutory meaning as opposed to just in a contract. The last one she mentions at paragraph 40 is re Llewellyn. I looked at these cases, but it seemed in my submission that Llewellyn didn't help. If we look at tab 5, which is a decision of Mr. Justice Sterling, there was a decision as to question as to costs, and you can see what the question was if you turn to page 322, where you've got the council's argument. In the middle of page 322, you've got Mr. Pearson in reply. The question as to costs really turns on section 53.2, section 23, subsection 223 of the Settled Land Act. It places the tenant for life in the position of a trustee. So it was, and if you look at the foot of the page, on the right-hand footnote, footnote 3, you've got the text of the section. In payment of cost, charges and expenses of or incidental to the exercise of any of the powers or the execution of any of the provisions of the Act. And then if you go on in the case, you go on to page 326. The question in this case seems to me to depend on the meaning of section 21, subsection 10. This Lordship read it. Must be observed that what's allowed is payment of cost, charges and expenses not merely of, but also incidental to the exercise of any of the powers of the Act. And I have to determine what force is to be given to the words incidental to. It seems to me that if any meaning is to be attached to them, it is that the tenant for life is to have not merely his costs, charges and expenses, which directly and necessarily arise out of the exercise of the powers and provisions of the Act, but also which, without being a direct or necessary consequence of the exercise, are incurred casually or incidentally in the course of that exercise. Now, if that's, and of course we're concerned, as I already said, with a contract, not with a statute, but if that's the sort of approach to be adopted, and you're asking whether the costs are incurred casually or incidentally in the course of that exercise, well, it is incidental in the sense of part of that decision that you have to go off to the FTT before you can serve your section 146 notice. So, I say this with considerable hesitation, if the second reason given by Lady Justice Arden is based on these cases to do with statute, including this case, then I would suggest that I'm helped by this case and not hindered. Now, my last ground to deal with is ground 4, which is the I just wanted to turn up now what Judge Cook had to say about that, which is in the core bundle, and it's paragraph 85 of her no, I don't think it is 85. No, 95. Sorry, I'm very sorry. 95. 95 of her judgment, page 115 of the core bundle. Now, you were read this, but I think with the emphasis in the wrong place. Reverting to the clause in question in the present appeal, I find its construction difficult. The purpose in the relevant clause is the management of the building. Of the cases cited by counsel, it comes closest to the one in Hyperion, although it's arguably wider because of the words in connection with. And indeed it is. So she was making a perfectly logical point when she was latching onto, we say correctly, that the significance of the wording that we're concerned with is in connection with, because the language of the covenant that we're concerned with here is in the supplementary bundle, and it's page 31. And if you look at paragraph 5, the cost of employing such professional advisors, so they will obviously include lawyers, and agents as shall be reasonably required, and it doesn't say for the management of the building, it's in connection with. And if it just said for the management of the building, then I could have some sympathy with the submission that's made on the part of the appellant. But it's in connection with, and we say that those words are often used in contracts of all kinds, and they are used, when used, are very wide words. And I've included, I don't think it's very helpful to read it all out. There's a section in Stroud's Judicial Dictionary where different context you've got those phrases. There is
But you come across it quite frequently in relation to arbitration jurisdiction clause.
exactly, my lady, and so I've included in the bundle of authorities the Asheville case, with which you're probably very familiar. It's tab 9 in the bundle of authorities. And I can deal with this very shortly. If you look in the head note, there was the arbitration agreement, the arbitration clause, and this is in the head note at big E. Any dispute or difference as the construction of the contract was to any matter or thing of whatsoever nature arising thereunder, or in connection therewith, such dispute or difference, etc. And then the discussion about those words. If you turn in the judgment of Lord Justice Balcombe to page 503, he then analyses the clause at the top of the page. I wasn't going to read all that he has to say, but he makes various points about the wording. And then he says at D, on the other hand, simply as a matter of the words used, which are of the widest import, I can see no reason why both these disputes, the state leading to rectification and misrepresentation on the statement leading to damages, should not in each case be a dispute as to any matter or thing of whatsoever nature arising in connection there with the contract. And so he's put in connection there with in emphasis. So that's the we say in connection there with are words that you do use if you intend a wide meaning to be met. And as you know, because I think my learned friend took you to this, there are provisions about the payment of a maintenance charge. The maintenance charge includes covenants that my clients will carry out things subject to payment of the maintenance charge, and the steps that we would then want to recover the cost for are the ones that are summarised in paragraph 5. Management clearly involves collecting service charges. So if you...
we've seen some authority which says that. I mean, I tend to agree with you, but is it common ground that management includes carrying out works and getting in payment for them?
I would hope so.
Well, Lord, if that was common ground, we wouldn't be here on ground 4, because I would be then conceding that the legal costs are recoverable under the clause. It's quite the contrary.
And is that because, as I think somewhere we've seen in the authorities, there is a suggestion which taking proceedings is not part of management?
Correct. There's a series of cases in which it is.
And have we got the reference in your skeleton?
The reference in my skeleton, we also looked at the West India Quay case, which was the management. And it's,
Thank you.
And my approach is I say that collecting service charges is part of management, and it inevitably means that if you've got management, then from time to time people will not pay their service charges. And although, as I've already said, I can see the argument, if it just says reasonably required of the management, that this is in connection with. And this was the point that Judge Cook, with her, tipped the balance into the decision that the costs were recoverable under paragraph 5 as part of service charges. And we say she was right to so decide. But she said she found the construction difficult, but these were the words that made the difference. And because they're wide words, we say she was right to do so. Excuse me, just one moment. Subject to any comments from the bench, those are my submissions.
Thank you very much, Mr. Warwick. Mr. Fieldsend.
Yes, thank you, Lord. A general point, there was some criticism levied at my client, which is not necessarily relevant to the exercise of contractual interpretation. Just so that the court is aware, it's not in the bundle because it's not relevant to the issues, but there was a Tomlin order, and the schedule was endorsed on the face of the order, so I'm going to say I'm entitled to reveal it to the court, whereby the defendant, so that's the landlord, agreed to pay my client £20,000 in full and final settlement, and agreed to pay certain of my client's costs. There was also a letter in which my client expressed her intent to set off a disrepair claim. It's in the bundle, back in 2014. Perhaps moving to some more substantive points, there is a material difference with rent review, and I alluded to it in my submissions. They weren't mine. I stole them, if you like, from United Scientific Holding, but part of the reasoning is this difference in, it's one that the landlord would be prevented from reviewing the rent. It actually goes more fundamental to that. It's the change in money, it's the consideration for a longer term. And if you need to see those references, page 946, B to C, from United Scientific, which is tab 7. This is taken from the speech of Lord Simon. Top of page 946, paragraph B, it was envisaged from the outset that rent would be reviewed during the currency of the leases. The clause is merely providing machinery for determination of the new rent, which in more stable conditions might have been stipulated in advance. Moreover, the clauses went to the very basis of the consideration moving from the landlords. In a period of inflation, the latter would not have granted leases for such long terms without inclusion of rent review clauses, and certainly the initial rent would in each case have been much higher without those clauses. To put it the other way around, the rent review clauses were integral parts of the consideration moving from the tenants, whereby they acquired a long term of years at an initial rent lower than it would have otherwise been. It's so fundamental. Then additionally over the page, now from the speech of Lord Salmon at the bottom of paragraph G, I would add that a well-advised landlord is hardly likely to agree a rent revision clause which laid down its provisions as to time were of the essence of the contract. Were he to do so, it would mean that should he take any step later than the time specified in the clause, and however slight the delay and however little it affected the tenant, he would lose the benefit of the clause for the next 5, 7 or 10 years, whatever the intervals for revision might be. In such circumstances, he might be left with a rent for that period of perhaps a half or even a third of the then fair market rent. Then over the page at 948, still in the speech, from the speech of Lord Salmon, runs from B through to E. The period, it's reiterating the same point as a period of acute inflation, such as we've experienced for the last 20 years or so, and may will continue to experience for many years to come. What is a fair market rent at the date when the lease is granted will become wholly uneconomic within a few years. Tenants who are anxious for security of tenure require a term of reasonable duration, often 21 years or more. Landlords, on the other hand, are unwilling to grant such leases unless they contain a rent reviews clause which will enable the rent to be raised at regular intervals to what then the fair market rent of the property demise. Accordingly, it's become the practice for all long leases to contain a rent revision clause providing for a revision of the rent every so many years. Leases used to provide for such revision to be made every 10 years. Now the period is normally every 7 and not infrequently 5 years. To my mind, it is totally unrealistic to regard such clauses as conferring a privilege upon the landlord or as imposing a burden upon the tenant. Both the landlord and tenant recognise the obvious is that such clauses are fair and reasonable for each of them. I do not agree with what has been said in some of the authorities, namely that a rent revision clause is for the benefit of the landlord alone and not for the benefit of the tenant. It is plainly for the benefit of both of them. It's for the benefit of the tenant because without such a clause he would never get the long lease which he requires, and under modern conditions it would be grossly unfair that he should. It's for the benefit of the landlord because it ensures that for the duration of the lease he will receive a fair rent instead of a rent far below the market value of the property which he demises. Accordingly, the landlord and the tenant, by their agreement in the lease, provide that stated intervals during the term the rent should be brought up to what is then a fair market rent. And that was the need then, per annum of Britain, look at what the purpose of the clause is as part of the exercise of interpretation. There's a fundamental difference between the purpose of a rent review clause and the purpose of the interim charge clause that we're under an analysis here.
Well, it's a difference of degree, isn't it? Because you could characterise this interim payment clause as being for the benefit of both.
I can see the compelling argument for that for the final charge, and that's why I wouldn't hesitate. I don't begin to suggest that times of the essence there, because then I can see it's in the interest that the landlord should receive its money, and I can see the purpose of the tenant being obliged to pay. But I don't accept that's the position with an interim charge, or where there's an interim charge which has already got a fixed sum.
Okay. And it's a necessary consequence of your submission that you could have exactly the same phrase relating to a rent review clause and, say, an interim charge, maintenance charge, in the same contract having different meanings, one being time being of the essence and the other not.
Yes, well, first of all, because as Lord Fraser said in his speech in United Scientific, you look at the clause. I think I accepted that in my outset, that you can have, I mean, indeed, that's inherent in my argument, because I'm saying time is not of the essence for part of the service machinery, but it is for other parts. The part which I'm looking at does work to the benefit of the landlord. It's not an estimate to say, I notify you so you can arrange your financial affairs. It is for the benefit of the landlord so it receives money on account to discharge against its obligations. But it will still always receive payment under the year-end reconciliation or the maintenance contribution. Maintenance charge, sorry. But that's why there's a fundamental difference between the purpose. The rent review is there to bring the rent up to present value, to re-gauge. There's no such necessity in our case, and there's no trade, because without that rent review, the tenant would have got in the outset. That's why it goes to the heart of the consideration. You do look for contraindications. I mean, not every rent review clause, time is not of the essence, because when it's linked to a break option, it's been said that time is of the essence, and the cases were not, page 936 from the speech of Lord Dicklot, he expressly said that the cases where it was linked to a break option were not overruled.
936.
936.
Thank you.
And indeed, so what 936? It's paragraph F. The remaining cases to which this House was referred in which time has been held to be the essence of rent review clauses which was not associated with a break clause should be regarded as overruled. And the reason why time is of the essence for the rent review is because it then enables the tenant to take a decision as to whether it wants to operate the break clause, and the break clause, it's being an option, time is of the essence. So the contraindication being because it's linked to the break option, the time is intended to be of the essence. And that's really, just running with the break option for the moment, Malone and friends place great emphasis, well, it doesn't work, because what if it's one day late, what if somebody stumbles on their way to the post office? But that's what applies when you operate a break option, that's what applies when you operate an option for the purchase of land. It's a consequence of time being strict. There seemed to be a suggestion that there was an ambulatory meaning that moves around as to whether, in residential cases, changing throughout the time depending on who is the landlord. That, in my respectful submission, can't work. It was said that the bar was being set to too high in the place of sell a house in the analysis. My learned friend referred to Gayford's, moments ago, paragraphs 39 and 40, as your ladyship pointed out, the deputy president there said it was not uncontroversial. His Honour Judge Bridge brought the three cases together and called the three cases, it's Seller House, it's Phillips and Francis. And they all say the same thing, it's about clarity. Lord Newberg is just expressing it in the same way. Don't bring anything into the clause that doesn't clearly belong there. It's the need for clarity. We can get distracted in looking for pragmatic solutions. That was an approach in Ireland and Britain itself, because what had happened was they fixed the review of the service charge at 10%, thinking inflation's always going to be running ahead of sales. When there was then a period of lower inflation, what happened was you ended up with an absurd service charge. I can't remember if it's actually in the judgment, but certainly the commentary calculates that for these modest chalets, they'll be paying something like £1 million a year by way of service charge by the term date of the lease. And yet he said, I'm sorry, but I can't rewrite the bargain. And that was the point about with the benefit of hindsight. My learned friend seemed to, contrary to his skeleton, where he says that the words of the 146 clause, in skeleton of paragraph 37(1), he said that they haven't changed their meaning. He seemed to be suggesting that at one point that they have an ambulatory meaning. If we just pause, my submissions as to what looking for clarity actually follows what Lord Newberger says in the 6th point in Arnold and Britain. We go back to Arnold and Britain at 24, tab 24. It has these 7 factors, and the 6th one is at paragraph 22. And this is where Lord Newey is talking about an unforeseen event. And he says, in some cases, events subsequent occurs which are plain or intended or contemplated. In such case, if it is clear what the parties would have intended, the court will give effect to that intention. So that's where you're searching for the clarity. And then, but you're always referencing it to what they had in mind at the time of the contract. Now, the relevance of the statutory landscape at the time of the contract is it helps you identify what their intentions are, not what their intention would be in a given circumstance in the future, because that's not foreseen. But you're looking at the landscape, the legislative landscape. And the relevant legislative landscape here, at this time, tells you that it wasn't their intention to capture costs of proceedings within that clause.
Yeah, I mean, you're putting it, I'm using slightly different language. You say it's part of the factual matrix that at the time there was no need to jump through various hoops and hurdles in court before you serve a 146, but there was a need to enforce it in a particular way, and the parties use the words costs against that factual background, and you say that can't therefore be intended to have extended to legal costs, because other than the costs of drafting the notice and so forth.
Well, I mean, it can't...
Cost of proceedings.
It can't go, yes, just to keep it...
Legal cost of proceedings.
Cost of proceedings.
Because cost of proceedings, because there were no proceedings, and you can't say, well, if you stood back and they had a crystal ball and they knew that there were proceedings, that they would have mutually intended that those costs should be encapsulated within the phrase, because it only works one way.
Exactly.
That's your point.
And you know that, we say, because you can draw that, yeah, exactly, that's what I say, you can do that with reference to the legislative landscape,
yes.
Which is why it is relevant to look at it. Maloney friend referred to the Shraggy case, which was a decision of Martin Rogers, Deputy President, where he says, well, I don't see how it works. But then there was the Gayfords case, same judge, we've already seen it in paragraphs 45 and 46, where he looks at the legislative landscape at the time and says it is relevant to the exercise of interpretation. I do submit that Cellar House does establish a principle. I think that is clear from Lord Justice Henderson's judgment in the West India Quay case. One can say that he isn't just simply adopting a sentiment. That might apply if they were the same facts. They're not the same facts. He says it's apposite. It's apposite because it emphasises the need for clarity. And that linking in Gayfords, paragraphs 39 and 40, Cellar House, Francis Taylor and Francis, and Arnold and Britton was replicated in the passage I referred you to, where His Honour Judge Bridge did the same thing in Lamb's Conduit Street. My learned friend misdirected you to what the clause was in issue in West India Quay. Paragraph 33. Paragraph 33. Tab 33. Beg your pardon. Tab 33. And it's paragraph 68. Paragraph 68, my learned friend took you to the clauses 6.1 and 6.2 and said, well, they're very, 6.1 and 6.2, and said they're very broadly drafted. What he overlooks is that there's a defined term in 6.2, which is additional items, and that's what then has to take you down to the clause that's cited at paragraph 70. Because that shows you what the additional items are.
Hold on, I'm sorry, you're ahead of me.
I beg your pardon, my lord.
You're in West India Quay.
I'm at paragraph 68.
Thank you, that's what I misheard.
My apology. So yep. Paragraph 68, my learned friend identified clauses 6.1 and 6.2 and used words to the effect, well, they're very general in their language or very broadly drawn. That wasn't the clause that was under consideration, because you'll see the defined term additional items in clause 6.2, and that takes you to the definition that was in part D of the schedule, paragraph 70 of the judgment, and that's the clause that was under consideration. And that's where you see the expression management. That's where you then have the Deputy President saying legal costs aren't captured by that. That's where you have Lord Justice Henderson saying Sellameers is apposite. That's where he refers to Lord Justice Taylor, where he talks of clear and ambiguous language, or not bringing within the clause anything that doesn't clearly belong there. And that's where he says we try sometimes it comes to the same result. And that's why, my Lord, Lord Justice Stuart-Smith, why I said to you that there are cases which say that management doesn't encapsulate costs of recovery and such stuff.
Well, I'm glad I asked.
I'm glad I had an answer. The Llewellyn case, which is an arbitration I tread carefully here, is not my area of expertise, but different context, and words obviously have to be interpreted in their context. But as I understand that decision, it was actually decided on what the purpose was of the arbitration clause.
Do you mean Llewellyn? You mean
You
Ashfield?
don't mean Llewellyn.
I don't mean Llewellyn. That's where I'm going wrong. Sorry, I mean the Ashfield case. Because it was actually decided on what was the purpose of the clause. Clearly, we can look at it. Clearly, the parties intended.
Well, I mean, Ashfield is one of a series of cases in which the courts have striven to give arbitration clauses the widest possible meaning, so that you don't find certain parts of a dispute falling outside of the arbitration clause. That's essentially what happens in Ashfield. I think it was a rectification of mutual mistake, wasn't it, that case? And the question was, is a dispute between the parties about rectification for mutual mistake a dispute which arises in connection with the contract? Answer, obviously, yes.
Yes, but it goes on, as I read, not my field, but as I read Lord Justice Balcombe, so in tab 9, page 503.
Yep. He says it's very wide.
Well, it's more than that. It's private. I may have misunderstood. Page 503. It's paragraph E.
Yeah.
I find that the meaning which I give the words that paragraph E as a matter of first impression is supported by the approach to the arbitration clause, which Mr. Lloyd submits correctly, in my view, that we should adopt. The approach is summarised in the following propositions. It may be assumed that the parties intend it, so it's focusing on intention. It may also be presumed that the parties intend it, it's focusing on what their intention was. And then it's applying a previous case. And then there's paragraph G. There's one further principle of construction that in my judgment supports the meaning which I attribute to this clause, that all words should be used so far as possible to be given their meaning. Disputes to the construction of the contract or to matters arising from the contract are covered by the opening words of the clause. So disputes as to matters arising in connection with the contract must be taken to refer to disputes other than that about questions of construction or as matters arising under the contract. So it's looking at the wording, it reaches the decision it does on the wording of the clause and identifying what the party's intention was. It's not simply saying, well, actually, I can give particular meaning to in connection with and reach that conclusion. It is also perhaps telling, if I can put my learned friend's submission this way, is that he appeared to accept that but for those words, these costs would not be recoverable. So what creates or generates recoverability is those simple words in connection with. And then we have the point I made earlier about, well, that would render OTOs the remainder of paragraph 7, what wouldn't be captured by the clause. I did have something to say on Llewellyn, and it was simply this. It was a different context, and it was ultimately as to the meaning of incidental to in a cost clause, in a residential lease, you have the decision of Lady Justice Arden. So insofar as it's necessary to look at one or the other, the contract real is the more it is the binding precedent. Bear with me 1 second. Thank you very all for your patience.
You won't be surprised to say we'll reserve our judgments. Thank you, both of you and those behind you, for excellent arguments, which certainly will take a bit more thought. In the normal way, you'll be supplied with the judgments in draft for typographical and similar corrections, but not, of course, to re-argue the case. I think in line with the practice that has now been adopted, the ultimate hand-down will be remote rather than in person. But even were it to be in person, there would obviously be no need for anyone to attend. As I'm sure you know, we'd be grateful if, in advance of the hand-down, you would seek to agree an order giving effect to whatever has then been decided. If there are any points of difference, we'd be grateful for short written submissions on those, and we would expect to settle those when finalising the order. So, thank you both very much.
My Lord, in relation to the extension of...
Oh yes, I'm so sorry. You're quite right. As to that, to make life easy, Mr. Fieldsend, could you put together a draft order, get Mr. Warwick to agree it, and then send it? You probably have my clerk's email address to you. If you could send it to her, and I'll make sure that it's drawn up. Thank you very much.